What follows is not just another headline in the endless cycle of Trump controversies. It is a moment that, according to legal filings and expert analysis, may represent the most serious threat yet to the financial and political structure Donald Trump built over half a century. At the center of it all is Mar-a-Lago, not merely a luxury property, but the symbolic and operational core of Trump's post-presidency power. According to court documents and reporting from multiple legal analysts, a federal judge has issued an extraordinary order transferring control of Mar-a-Lago to a court-appointed receiver as part of an ongoing investigation into alleged financial fraud. While Trump retains ownership pending further proceedings, operational authority has reportedly been removed, meaning the property can no longer function as his political headquarters, fundraising hub, or private command center. To understand why this matters, you have to understand what Mar-a-Lago actually represents. Since leaving the White House in January 2021, Trump has used the property as far more than a residence. It has served as a shadow White House, a political court where Republican leaders, donors, and aspiring candidates travel to seek favor, endorsement, or forgiveness. Decisions shaping the modern Republican Party were not made in Washington, but in Palm Beach. For years, Mar-a-Lago has been the beating heart of the MAGA movement. Major donors wrote seven-figure checks there, leadership fights were negotiated there, presidential ambitions were born or buried there. Symbolically, it replaced the Oval Office as Trump's seat of influence. Removing his control over that space is not just a legal maneuver, it is a direct strike at the infrastructure of his power. The legal case itself centers on a familiar but devastating allegation: systematic misrepresentation of asset values. Prosecutors allege that Trump repeatedly inflated the value of Mar-a-Lago when seeking loans while dramatically deflating it for tax purposes. In one set of filings, the property is allegedly valued in the billions. In another, it is treated as worth only a fraction of that amount. Legal experts are unanimous on one point: doing either of those things alone can be aggressive but defensible. Doing both over many years, across multiple institutions, is what turns aggressive accounting into potential criminal fraud. Prosecutors argue this was not an accident or a misunderstanding, but a deliberate pattern designed to extract maximum benefit from banks while minimizing obligations to tax authorities. This investigation reportedly began at the state level, but expanded rapidly when federal authorities identified potential violations involving interstate banking, federally regulated lenders, and cross-state financial disclosures. Once federal jurisdiction was triggered, the scope of the case widened dramatically. What began as a dispute over valuations evolved into a sweeping review of Trump's broader financial practices. The seizure order itself is highly unusual. According to former federal prosecutors, courts almost never strip operational control of a major asset before final judgment unless they believe there is a serious risk of continued misuse or dissipation. In plain English, the judge appears to have concluded that allowing Trump to continue operating Mar-a-Lago as usual posed a legal or financial danger. The language attributed to the order is unusually blunt. Analysts note that when judges describe conduct as showing willful disregard for legal and ethical boundaries, it signals deep skepticism toward the defendant's credibility. Judges are trained to be restrained. When they are not, it is intentional. The financial context makes the situation even more perilous for Trump. For years, his public image has rested on the idea of immense personal wealth and business mastery. Yet recent reporting suggests that much of that wealth is illiquid, highly leveraged, and under legal pressure. Properties that appear impressive on paper may generate little cash once debt service, legal fees, and operating costs are accounted for. Mar-a-Lago, by contrast, is reportedly one of the few Trump assets that consistently produced positive cash flow through memberships, events, and branding. Losing control of it, even temporarily, creates immediate financial stress. It also weakens his negotiating position with lenders, insurers, and political allies. This is where the reaction from the broader financial community becomes critical. Following news of the seizure order, Warren Buffett made rare public comments that, while not naming Trump directly in every instance, were widely interpreted as a rebuke of business models built on deception rather than fundamentals. Buffett emphasized that markets eventually punish dishonesty and that no amount of branding can overcome bad math. For Buffett to speak at all is extraordinary. He has built his reputation on avoiding partisan fights and refusing to comment on individual personalities. According to people familiar with his thinking, his concern is not political but systemic, that normalizing exaggerated valuations and financial shortcuts corrodes trust in American capitalism itself. Buffett reportedly confirmed that Berkshire Hathaway had been approached years earlier about potential exposure to Trump-branded properties. After reviewing the books, Berkshire declined. The reason, according to Buffett, was simple: the numbers did not align with reality. In his world, that is not a political judgment. It is a fatal flaw. That assessment strikes at the core of Trump's self-image. For decades, Trump has presented himself as a peerless dealmaker whose instincts outperform experts. But when the most successful value investor in modern history looks at your finances and walks away, it raises uncomfortable questions about where the illusion ends and the balance sheet begins. The legal fallout does not stop with Trump. Banks that facilitated these loans are now facing scrutiny of their own. Internal communications cited by prosecutors suggest some executives were aware that valuations were questionable, but proceeded anyway due to the profitability of Trump-related deals. If proven, this could expose financial institutions to serious penalties and individual executives to personal liability. This pattern where enablers support Trump until legal risk becomes unavoidable is not new. We have seen it repeatedly in his political career. Jeff Sessions was embraced until he followed the law. Bill Barr was praised until he refused to lie. Mike Pence was loyal until he upheld the Constitution. In each case, loyalty was transactional and conditional on absolute compliance. The same dynamic now appears to be unfolding in the financial world. Accountants, lenders, insurers, and donors are reassessing their exposure. Several major Republican donors have already signaled that they are distancing themselves from Trump-aligned political organizations, citing legal uncertainty and reputational risk. When figures like Ken Griffin publicly express concern, it matters. Griffin is not a moderate voice. He is deeply embedded in Republican fundraising networks. His withdrawal suggests that even hardened political financiers see danger ahead. Legal scholars across the ideological spectrum agree on one thing: this case is not easily dismissed as political persecution. Conservative analysts who have defended Trump in the past acknowledge that the valuation discrepancies, if proven, are indefensible. Fraud is one of the few crimes that cuts cleanly across partisan lines because it is easy for ordinary people to understand. Everyone knows you cannot tell the bank your house is worth a fortune while telling the tax collector it is nearly worthless. That is not a culture war issue, that is basic honesty. Trump now faces a dilemma with no good exits. If he fights relentlessly, appeals every ruling, and refuses compromise, he risks catastrophic losses that could strip him of multiple properties and potentially expose him to criminal penalties. If he negotiates, he may preserve some assets but destroy the myth of invincibility that sustains his political brand. That myth has always been central to Trumpism. He is not just a candidate, he is a symbol of defiance against consequences. Admitting error, even strategically, threatens the emotional contract he has with his base. What happens next will test the American legal system in profound ways. If courts follow the evidence wherever it leads, it will reaffirm the principle that wealth and office do not grant immunity. If political pressure, delay, or procedural maneuvering allows accountability to be avoided yet again, the damage to public trust may be lasting. This is why Mar-a-Lago matters. Not because of its chandeliers or golf courses, but because of what it represents, the intersection of money, power, and accountability. The question is no longer whether Trump is controversial. The question is whether the rule of law can withstand someone who has spent a lifetime testing its limits. The coming weeks will be decisive. Appeals will be filed, narratives will harden, supporters will mobilize. But beneath the noise, the case will turn on documents, numbers, and credibility. Math does not care about rallies. Spreadsheets do not respond to slogans. If the allegations hold, this will not be remembered as a political takedown. It will be remembered as a reckoning long delayed.